Hello, everyone. We're back with another episode of Life in Law. And our special guest today is actually somebody that we talked about in our last episode. And his name is Joe Gritz. Thank you so much for joining us.
Salute.
And so I know we mentioned you a little bit in the last episode and talked about how you were recently convicted after you represented yourself pro se in some criminal charges in Bridgeport. And Lawrence Dressler, who is a former or suspended attorney in Connecticut, uh, gave his opinion about some of the stuff about your case. So why don't you just tell everybody kind of in your own words what happened and why you were arrested and what was that all about?
So I guess I'll go back to last year, um, March 31st of 2025. A close friend of mine's, by the name of Daishan Best, was murdered by um, a Bridgeport police officer in Bridgeport, Connecticut. Um, the officer who shot him, and also the officer who chased him into a parking space that he was killed at. Um, Basically, me as a community activist, as a community leader, I went about like with a few protests the following days. Actually, I was the last person at the hospital to leave the hospital the day that he was killed. So I was the first one to actually speak to the news on his behalf. Obviously my friend's deceased, but I was the one that spoke to the News 12, and kind of was grieving and just letting the news know who he was, and the pain that I was feeling. um Being that over the last 15 plus years I've been an activist, I pretty much have spoken for many families throughout Connecticut, dealing with police brutality. This was the first time it hit home, like somebody that I actually knew prior to the murder. So days after that, I was posting on Instagram and Facebook, just grieving, just speaking on how I felt. Um, an organization that's in Hartford or New Britain area made these most wanted posters that had the officer who shot my friend, and also the officer that was his partner, which was a woman, a female cop, faces on it that said most wanted. And basically, if anybody has any information, call this number, and so on and so forth. The organization name is Dare to Struggle, and I think Family Against Violence. The Instagram, the email was on that most wanted poster, and everybody in that time, I think this is like the first, the second of the next month, which is April, shared the most wanted poster. Everybody, I mean, people that had no idea of the situation just learned about the situation and shared. My Instagram is a public open Instagram. Um, I run it, as well as other people media manage and run it, collaborate. I don't mind them things because I'm a hip hop artist, I'm an activist, and I'm number one, I'm a father. So I'm not always able to sit there with my phone and make these posts. So other people make posts and collaborate and just keep people aware of what's going on with me. Even in the event of me going to prison, somebody will continue to let people know what's going on with me. So a post went up with the most wanted poster, and then also a post where the officer's face was there, and then a lyric from another rapper named Boozy Badass, who's a Baton Rouge, Louisiana artist, and he's a older artist than me, and well known, like as far as known all throughout the United States. And all his songs are known throughout the United States. And the lyric was, somebody should die. Somebody should die with a badge on. It never was any post that said somebody should be killed, somebody should murder this officer, or anything of that sort. It did have his face as the officer's face on my Instagram page. It did have his face.
So wait,
Um,
hold on. I don't mean to
but
interrupt you. So just to clarify, so was it your lyric or another artist's lyric that
no,
they were
that
quoting?
that that actual lyric was a Little Boozy lyric. I had my own song called Black Boy Don't Run, which is still streaming on all platforms. And I say a bunch of stuff in that song as well. But the my evidence for this charge, they was using the Boozy lyric caption under the picture.
So did they actually
Um,
like play the audio of the song, or was it just only in a caption?
it was only in the caption for that. And while it was only in the caption, the story for Instagram, Instagram has the stories. It
Hmm.
was the same picture, but then on this story, it had a Beanie Siegel, another famous rapper, big time rapper, was signed to Jay-Z. So, somebody who's very popular. It had
Hmm.
his song, which his song is called Die. But in his song, it has no mention of murdering, assaulting anything to no officer. The only thing he says is basically um, different ways that people die through the street, and basically saying you could avoid prison, but you can't avoid death. We're all gonna die. Um, and like basically karma for your actions. That was under the picture in my storyline. They used that as well and used that song as well. And once again, for those that's watching, Google, YouTube, stream Beanie Siegel Die, that song Die, and you'll see there's no, I don't even think in the song he referenced an officer at all. But they use this in my charge to build the case against me. So from that, from my police reports and different things that I looked into, assistant chief basically told another officer, like, look at this guy's Instagram. We got to get him. Like, he's boosting the anger throughout the community with what's going on. Um, During my trial, I found out that they contradicted each other because one officer said he knew of me, he saw me at protests.
So I just put this on the screen just so people can see, like, and
Okay.
it's like,
Oh, okay.
if
Yeah, yeah. So you
there's a
got
lot of
yeah,
artists, and it's interesting because there's a lot of artists out there who say things like, for example, Eminem comes to mind, that there was
right,
always like disputes about his lyrics, and then you see a lot of times these rappers will come out with like a clean version and sometimes change the lyrics, like not even just censor the word but change the whole lyric
right,
completely because it's
right.
so inappropriate or bad, or they'll have to say it's explicit or whatever. But from what I understand from like a legal aspect is that it's supposed to be like your artistic freedom, where if
Yeah,
it's
yeah.
rapping, if it's a movie, if it's something that's art, you're allowed to say something. It's creative. And if you're
Since the
if you're if
beginning,
you're
the beginning of well, I'm a hip hop artist, so the beginning of hip hop. I mean, we go back to the '80s. I was born in the '80s. NWA with Fuck the Police. Um I think KRS-One has a song about cops, and yeah, it's art, it's an expression. Even watching your platform and hearing the attorney speak on um the movie directors, because all I do with my hip hop is I paint what's my reality of what's going on in my neighborhood and what's going on in the world. And it's just like an artist with a canvas, and they just paint a picture. So as you have died the lyrics up there, I believe you could read the lyrics out and see. I think when I for the
which
story
part
of
which
it was
part
the
was like
hook.
the
It was the
audio?
it was the hook. Uh Chapters of the same book. Just a day. I can't see what you're looking at,
I
but
mean,
yeah,
chapters of the same book, just
yeah,
different
there you go.
page.
Yeah,
This
yeah,
one,
yeah. That's what was posted.
that's what
That
was
was what
playing as the
in
audio,
the
and
back.
they got mad about that.
Yes. And if you read that, for those who can't, it says we chapters of the same book, just a different page. Niggas of the straight same struggle. all out to get paid, doing what we got to do to avoid the raid, avoid the cage, but you can't avoid the grave. And that's, I you could say I'm a hip hop expert because I've been a hip hop artist for over 25 years. Basically, all he's saying in that song is, um, you could avoid the cage, avoid prison, but you can't avoid the grave. Like no matter what, you're good, you're bad, you're happy, you're evil. We're all gonna die, and
Yeah.
that's all it was saying. Nowhere in that whole lyric do it say anything about doing any harm to any police officers. And me, once again, being a hip hop expert and knowing Beanie Siegel, he wasn't talking about police in that song. He was talking about other street people that's in the street committing crimes and doing different violence and things like that. And
Yeah, and that's
drugs
what I'm
and different
saying.
things.
Like, did they subpoena Beanie Siegel as a witness at the
Right,
trial to testify what he meant by that lyric? Because
right.
if not,
Th-
then they can't just assume that the artist meant and that you're applying. Because I could take that lyric and say it means 10 different things. It's whoever
Exactly.
is interpreting it. And if you really want to know what it really means, you have to ask the person who wrote it, who may not even be him. Look, who wrote it? Not him. Who's
Exactly. And
Gavin,
that's the
Paul, all these
thing.
other people.
That was the thing. I was trying to get. I know it would have been hard, but that's what I was saying myself. Like, let me subpoena Beanie Siegel. He could tell you what he meant. And then on top of that, I had on a flash drive as my evidence was the actual song. They never allowed me to play it in court, as well as the boozy the caption and things like that. I was trying to present these things, and everything was getting stricken down.
So wait,
And
let
once
me ask
again,
you a question. Sorry. Did you fill out like an application for a subpoena and they denied it?
um, yeah, the motion that I submitted had everybody who I wanted to be a witness up there, and they denied it. And some people, even the officer, that one of the officers that handcuffed me and arrested me, I had him as a witness because I wanted to just even show our interaction. I didn't try to fight back or anything. And that as well was stricken, and I never was able to interview him. Only witnesses was um the officer who's feeling like he's threatened, um, the officer who was first told to investigate me, and then another officer who was at the precinct at the station when I went with Daishan Best, my friend who passed. I went with his family to speak to the chief of police.
Okay, because like I know in Connecticut, if you're a lawyer, you can just sign a subpoena for anyone that you want and force them to come to court and be a witness. But if you're pro se, you have to fill out an application for the court to grant you a subpoena, and then the judge can say yes or no. And then if the
Right.
judge denies it, then you can ask for a hearing on the denied application. So did you actually fill out like that form JD whatever about asking for applications for
I
subpoenas, or did you just give a
no.
list of the witnesses you wanted?
Yeah, I made like a motion and gave the list.
And
And
can
then
you
mind you,
explain,
go ahead.
sorry, can you just explain why you didn't get a public defender so people understand?
Number one, I never was gonna get a public defender. I was incarcerated when I was 18, 19 years old, for drug charges and robberies, and I did 4 years in prison. I had a public defender, which now me, being a little bit more educated on law and things like that, I don't believe my 14-year sentence I would have got. I ended up doing 4 years and a 10-year special parole. So I never had belief in the public defender because I know their office is right across from the state. And for me, being more educated and being around the legal system for the last 20 years, I know that when they call recess, the public defender and the state's attorney probably go out to eat and they're friends, and they basically treat us like pawns and puppets, and they pick and choose like who they want to help and who they don't, or we'll let this slide if you help with that. So I never was going to get a public defender. The lawyer that I would have used actually end up having legal matters on his own, and then he was actually convicted of his legal matters, and it was just a best choice not to use them, because we know with the media and even whatever with the judicial system, that they was gonna use that, like, look, convicted lawyer represents suspect, or however you want to paint it. So I end up using the knowledge that I do have on the legal system, and wanted to go pro se. Along the whole year that I've been waiting until the trial, yes, I absolutely got advice from other attorneys and seek other attorneys, but financially it was hard for me to just get any attorney, because this charge hindered me from doing the maintenance work that I do, as well as me being a hip hop artist. So when it got close to trial, I did my sentencing appeal. My sentencing lawyer that I have now, me and him had talks before my trial started, and he was willing to represent me. But they sped the trial. Like, they literally gave me like 4 or 5 days to get ready for trial. So when I went to the hearing to pick the jury, I told the judge, I said, if you give me a reasonable time, I could obtain legal counsel, because I already had the conversation with the lawyer. And they never judged on that. They just skipped everything, and we went to pick the jury. Then the first day of trial, I said it again. And all of this is on record. I said it again. And when I said it again, they never ruled on it. They just went through with the trial. And that got me to being pro se and just trying to fight it myself.
Yeah. So, like, when you first were arrested, what date was that?
April 7th, 2025.
Okay. And you know what? Before I get into this other thing, I just wanted to say what you said about the public defender. It's 100% true. And actually, like, I went to school at UConn Law, and like when I was doing an internship where a lot of the students were doing internships for credit, where they go and work for free at like the courthouse and the clerk's office or the public defender's office or whatever. And then they get school credit for doing that, but they don't get paid. Right. So like we would have to do like a mandatory class like once a week or something with a teacher, and everybody would have to like participate and talk about their internships. I was doing mine at a personal injury firm, but this other girl, actually more than one, couple of the students, they were doing theirs at the public defender's office. And so when it was time for them to like raise their hand and talk about what they're doing, one girl was like, oh, we go there in the morning and we all sit down together with the prosecutors and we all have our coffee in the morning and we talk about all the cases that we have that day. And, we say about what we think about the cases. And I'm like, and I raised my hand. I'm like, don't you think that's a conflict of interest to have the state sitting there with these attorneys and just openly discussing everybody's cases all together like that in a group setting? Like, doesn't that violate like attorney-client confidentiality? And also, isn't it like a conflict? Because now you're going to go in front of those same clients later. And the teacher just quickly tried to shut me up and didn't like that question at all. And then so then they started retaliating. And actually the dean, Paul Chill, he said to me, because I dealt with corruption in like May of 2023 in the family court, I told my professors about it because they're all lawyers. And so like, I'm over here asking every organization, all my professors, the school, everybody for help. And everybody's telling me, just keep your mouth shut, get a lawyer, get a lawyer, get a lawyer. But these lawyers are trying to extort me, saying $200,000 to take your case to trial, 50 grand just to look through your case, 30 grand just to look through your case, when I could give them a 1-page summary of the entire case and tell you it myself. Like, I'm in law school. Right. Why would I need you to spend 30 grand to look at something that's so simple? You know what I mean? Right. So it's like, they're just trying to play you. And then meanwhile, they're saying, oh, this judge is so fair, when the judge is like breaking the law and stuff. So in Connecticut, this corruption is everywhere, not just in the criminal courts. And so when I went to the school and I said, I'm going to file a federal lawsuit, I'm going to file an appeal, this is illegal, broke the law. The dean said to me, listen, if you file an appeal or if you file a lawsuit, even if you win, you'll never be a lawyer in any state in the country ever. And I'm like, what do you mean? Why not? And he's like, because you'll never pass the bar. You'll never pass the bar for character and fitness if they see that you questioned a judge, sued a judge, or went against them. And I said, but what do you mean? They break the law and they're violating my rights. Like, isn't the whole point of being a lawyer to like stand up for your rights in the law and like uphold what it says? And they're like, he's like, oh, well, it's one thing to accuse a judge of making a mistake, but it's something else to say that they lied or were biased. I'm like, are you trying to say that you don't think a judge can ever lie or be biased? And he's like, oh, I'm not saying that, but, dot, 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 like, and I'm just like, listen, like, what do you mean? And they basically are like, well, if you do choose to do this and decide to continue with your degree, you're not getting a refund. And don't be surprised when you'll never be a lawyer. So this was like coercion of them trying to like bully me to drop out. And like, after a certain point, I said to them, like, I'm going on a leave of absence for personal, medical, whatever reason. And that's it. And so it's like, I haven't been back in the school for a while, but I didn't drop out like they wanted me to. They wanted me to just drop out. And then like all these fake criminal cases that they're throwing at me in my case and stuff, which I don't know if you know too much about it, whatever, but I'm dealing with that in Milford court where it's like, I was arrested in 2023. The speedy trial law says they have 12 months to take your case to trial from the day you're arrested if you're not incarcerated. And it's 8 months if you're incarcerated. But it's been 3 years and change since the first charge. And it'll be 3 years in October for the second felony one, which is a violation of protective order because I was arrested for calling the police for him violating the protective order. And instead of arresting him, they arrested me. And then now they put a protective order protecting this grown man from me, saying that he needs to be protected from me. And then when I went to my child's doctor to get records that show child abuse, by the way, then I get arrested at the doctor's for interfering with my ex because he called the police and said he didn't want me there, even though I didn't see him at all. And the protective order doesn't say I can't go to public places if he's there. It doesn't say anything like that. So there's no reason to say it's a violation. Like if I say I have a protective order on you and it's a no contact, but then you're at the mall and I'm at the mall too, and I just don't talk to you and you don't talk to me, but we're near each other, nobody violated anything. If it says stay 100 yards away from me, then it's a violation. But if it doesn't say that, it could say stay away from your house. If you see me at Walgreens, you just don't talk to me and you didn't violate, right? So me going to the doctor is not a violation. Milford PD sends a squad, 3 cops, arresting me on the spot, question me without reading me my rights, leave marks on my wrists, kick me, put so tight it left marks on me. For what? Because I went to go get records. That's my legal right to do that under federal law. And so it's like Connecticut is out of control because when these police departments like Bridgeport, Milford, Orange, a lot of them are racist, misogynistic. They act like this old boys club where they do whatever they want and the state backs them up because then they send them to court and then the prosecutor and all these public defenders, they also have absolute immunity because Connecticut passed another law that says if you're a lawyer that works for the state, you can't get sued. So if you have a public defender, they're going to mess up your case. You can't sue them for malpractice like you could sue a private lawyer because they're a state lawyer. So I looked up because you told me that didn't they wait until days before your trial to give you discovery?
Yeah, a lot of the motions that I put in, mind you, I put in a lot of motions. I'm talking about I can't remember how many because I really throughout the whole year was just putting in motions, but all of those motions didn't go through or was heard until the day before. I think like 2 days before the trial, I had like a big hearing on all the motions. Mind you, I've been asking and asking throughout the past year while waiting, but I've had one, three judges. I've had two from the day of arrest till up until trial. Then they gave me another judge for the trial. So it's three judges and two prosecutors because the woman that was my prosecutor for the trial only came on the case maybe a month or two or something like that before that. Before it was another guy who they claim, quote unquote, dropped out because he got a higher position in the state attorneys or whatever the case may be, which I think that was a lie. I forgot his name, but the first prosecutor I had actually was a part of the Democratic Town Committee, which my younger cousin is a part of the same Democratic Town Committee. And I don't want to say they're friends, but obviously they're in the same circle at conventions and things, and they had a conversation. And I believe he only dropped out because he felt it would hinder the relationship he has with my cousin. Like I said, when I went in front of the judge, they gave me a whole nother excuse, but it was just coincidental because right after I spoke to my cousin, like for instance, let's say it was a Monday, then the court date was Friday, and then he drops out. It just was like a little odd to me, but.
So when did you first file your first motion for the discovery? Very early?
Yeah, definitely,
And
definitely
did it
3 months in, 4
granted
months.
or was it
They
denied
they
or they ignored it?
if I believe the first time it was ignored for a while, then they gave me they gave me like little pieces, like they'll give me like the police report, but in my motion I'm asking for everything, video cameras, everything, every little thing, precinct, hallway, everything, and
Mhm.
just nothing would come until when it was set for the trial. Then I basically had 2 days to like study and look through all these videos. They was giving me videos like days before the trial that I even still have on my laptop that I like watch, but it didn't even matter because wasn't able to use any of the videos. I actually filed a complaint. When I was arrested, they took my phone. They took my phone and they kept my phone for 4 months. So I filed a complaint with the Internal Affairs, and I did an interview with them. And the officers that arrested me did an interview with them. So that interview I used for my trial. Because when they took my phone, they extracted everything off my phone, but they found nothing that they was thinking I don't know if they thought they was gonna find like a blueprint to me trying to assassinate this officer or harm an officer or blow up the precinct. But that's what I'm pretty sure they took the phone for. But when they found out it was nothing on the phone, now when the trial comes up, the prosecutor says, when I'm trying to present like the contradictions in what the officers said to the IA, now they don't want to use none of that as evidence because they contradicted themselves from what they said on the stand, from what they said during the IA investigation. And like I said, little pieces like, oh, we don't know who Joe Grits is. We never heard of him. But then they'll say in the report that, oh, we've been following him, his Facebook before, the murder of Daishan. Because I believe the threat wasn't what they're saying with the initial charges. The threat was me just being me, who I've been to the community, and always the guy who exposes the police and the government's corruption. And that even till right now, that's it. Even doing this interview with you is the reason why when I was convicted last month, they upped my bond and took me in because they don't want me to speak out. And they made my
Oh,
condition to release that.
so wait, so you were convicted on what day? When was the trial?
June, the trial was the first day was like the 29th of May, but I was convicted May 31st, I believe.
So May 31st at court at the end of the day, they raised your bond right then and there.
They raised my
For
bond.
how
They
much?
took me 150,000.
Cash?
Well, no, well, bond. I mean, I got out on bond, but they made
Was
it
it
the
a wait,
condition.
was it a cash bond or a normal bond?
I believe
Like,
a normal. Like I
okay.
use a bondsman, like a
Okay.
normal bond.
Hmm.
But when they did that, they made the conditions of release that it was a court order condition of release. So it was a Friday.
Hmm.
So even though I had the money to get out Friday, court's over. So my case was, I went to court at like 2 o'clock. So as soon as that was over, court ended, and then I had to get out on Tuesday because my people had to pay the bond first at Bridgeport Correctional Facility, and then I got released on the 2nd, which was a Tuesday. And then I was given the conditions of release, like no internet and no posting about the officer or the case. Which the next day I went back and put a motion in and fought that, which they allowed me to post because I'm an entertainer and my 99% of my income comes from um, Facebook, Instagram, iTunes, and things like that. My engagements is how I get paid, as well as I do shows as
So
well.
wait a second. They told you you can't use the internet.
At all.
How are they going to know if you use the internet or not? Like, what
Exactly.
kind of stupid shit is that? Like, I'm sorry,
It
but
was outrageous. I mean, everybody was like, "Wow!" They've never even heard of that before. I've never heard of it before.
what?
But
What
so
does that
yeah,
mean?
so
You
the
can't watch
next
TV. You can't watch Netflix. That's internet. Like what?
so when they did that, like I said, I went the next day and I fought that. Because when I got out, it was by another judge. So she was like, we'll continue it till tomorrow. I'll release you now, but we'll continue it till tomorrow so your judge could clarify it. And then when I spoke on it, I'm like, well, you giving me a month till sentencing. I still have to bill, cell phone. I still got to pay stuff. I got children. I got 3 children. I still have to do stuff. So he was able, he changed it where it was just no posts about the officer and about the case. So me going around the bush, I use, like you, for instance, your platform and other platforms to speak on the case. But my social media has been just me speaking on my music and different things like that.
So I just looked up here. It said like about your case. They actually even put it on the Connecticut ct.gov website about it. A press release on June 2nd, and it says that you were found guilty of inciting injury to persons, which is Connecticut General Statute Section 53A-179A. So I just and we'll start with that one. In order to convict you, they must prove that you made a public or private statement orally, in writing, or in any other manner with a specific intent to provoke violence or unlawful destruction. So did any violence or unlawful destruction happen from that post or after that post?
Absolutely not. Not even till today, which would make it 14 months since the post. Even on the stand during trial, I was able to cross-examine the officer, and he even said nobody ever came to him trying to, cause him harm. Neither one of us seen each other ever until the trial day. I never seen that officer in person. Never contacted him. Like I told you earlier, nothing in my phone led anyone to believe that I was trying to do any harm to him. So no, absolutely not. To no officer, nobody was harmed, threatened, or anything by me or anybody else on my behalf.
And why did they not allow witnesses and video? What was their reason for not letting you have evidence, videos, and witnesses shown at your trial?
You know what? That on my part, that was my lack of education with the legal system. I'm not sure why. Everything was just stricken from me using those, as in my defense.
So you didn't really kind of ask why. You were just kind of like going along with the process, and then
Yeah, during the trial,
now
yeah,
you're
because
sort of, did they
it was
give you any leniency for being pro se?
no.
They didn't make you do a competency exam or ask
Oh
you about your
oh
education?
They did that last year. Yeah. I was held competent.
So,
Yeah.
so they made you see a therapist or something?
No, the judge just asked, I don't remember what questions, but he asked like 10 questions, and you know, he took it that I was okay.
Did they ask you if you had like legal background and reading about
Yeah,
legal stuff?
yeah, you know, no actual legal background as far as education wise, but I've represented myself in a matter that happened in Milford in 2020, and I was, you know, they dismissed that. You know, I went all the way up until trial, and then they dismissed it before we actually started the trial. So that was my only, and then I got, I mean, probably I'm probably undefeated when it comes to like parking tickets, driving tickets. I always go to max with that and end up found not guilty.
When are you going to be sentenced?
Monday, July 27th at 2 p.m.
In Bridgeport?
in Bridgeport, Golden Hill.
Okay, hold on. I just wanted to look up one more thing here, and then I was going to read this thing that I looked up before. So basically, yeah, so I basically kind of just like did a search kind of about like what you were saying and stuff like that, just briefly. And because I know that the other day I did a little bit of research about the discovery issue, because usually the state has like 45 days from when you ask for the discovery. Like usually you have to do it like in writing. So if you filed like a motion for discovery, they only have like a little bit more than a month and a half to give it to you. They can't just keep giving you 2 pieces here, 3 pieces here, whatever, because you need enough time to review it.
Right.
And like, so that could make like serious issues that you could like bring on appeal. But also the state like had a duty to disclose like exculpatory or impeachment evidence, any evidence that would be favorable to you, regardless of whether you requested it or not. They have a duty to give it to you. And that's under Connecticut Practice Book 40-11B. And so basically also like it doesn't give you enough time to investigate and examine the evidence. It doesn't give you enough time to look at or subpoena, to look for and gather or subpoena witnesses. Doesn't let you have time to hire any experts or consult with any experts. Doesn't give you time to authenticate any of the records or videos. Let's say they give you this video and it's edited. You know, you can hire an expert to prove that, but if you're only getting the video 3 days before trial and you're not even allowed to use the video as an exhibit, then then it's violating the whole process. Also, you can't you know, incorporate it into your strategy for defending yourself if they're not giving you enough time to look at it and they're not following the practice book. And it says the Connecticut Supreme Court has explained that evidence disclosed during trial may still be prejudicial when the defendant cannot effectively use it because of the late disclosure. And the controlling question is whether the disclosure came so late that the defendant was denied a fair trial. And giving it days before is not enough time in any sense for anybody. And a pro se is supposed to be lenient. The United States Supreme Court has said that they have to give you a little more leniency, not 100%, but if you're pro se or you're disabled or both, you're supposed to be allowed a little bit more leniency. And also the fact that you weren't allowed to call your witnesses, it says that you have a constitutional right to present your defense. And so, you know, the courts will look at, was the witness excluded because was it a technical thing that you didn't fill out of paper? Was it because what they were going to say was irrelevant? Like, what were the reasons why they denied it? If they just denied it for no reason, then that's not okay. You can, you know, bring those up and appeal. And then about the videos, you know, if you tried to introduce those videos, did you try to bring them up as evidence during the trial?
I had them, you know, the flash drives with everything, the videos, The song, like the Die song, the Beanie Siegel, I had that on a flash drive. Nothing was able to, yeah.
Okay. So yeah, so as far as that first charge, basically that's what it's saying. Like, so if it's saying you're making a public or private statement, what did they say that to convict you on that? How did that fit that statute?
That's why, I mean, I really don't know with the jury. I don't know what did they hear that made them, like you said, like that made them feel like, because
Well, what did the
even
state
from,
say? Like when they were saying their closing arguments and their whole story of their whole side of the story, how were you inciting? How were you
but
making
their
statements that
their
were made
thing was,
in an intent to provoke violence or unlawful destruction? How is it that?
their thing was to basically keep and mind you, the jury was predominantly born in the 1960s, right? Their thing was he has a big following. They kept like that was like the state's big thing. Mind you, on Instagram I don't have Facebook. I have 11,000 followers, but Instagram I don't have a lot of following.
How
But
many followers was it on Instagram?
man, probably like 4,000, something light. But
That's
I don't
crazy.
know. Yeah, that's what I'm saying. But the way they circled it on the screen, and like I said, the people that was sitting in that jury box, I feel like to them probably not being so social media savvy, they're thinking like this guy's bigger than what, because of how the state was putting it. But
So
you and
from
I
the
know that's nothing.
so from the day that you asked for your speedy trial to the day that the jury selection started, how much time was in between?
Wow, I'm
Because you
telling
said
you, it
you
was,
said it was like a year after you got arrested. Because like
yeah,
people that don't know, you can ask for a speedy trial, and then they have 30 days to take your case to trial. Usually, the
right,
state won't be ready in that time, but it looks like in your case, they were like, "Oh, we're not ready, so we're just going to rush to avoid having to statutorily dismiss the
right.
case." So that's why my
And
question,
them
like, you
and them
filed it,
knowing I'm pro se, yeah, they
they
probably
try to
just felt
trick
like
you. They're trying to just do whatever they can to trick you. But I'm saying like jury selection, how many days did that take?
jury selection 2 days.
And so during it, how many jurors did you say no to?
Probably like 4 or 5 out of the 20. I
And
believe
how
it was
many did
20.
they say no to?
I would say maybe if I did, I think I said it more. So I would say 2 or 3.
And so did when you were doing jury selection, you were both, it was like the state had the prosecutor and you and then the juror in the room together.
Yep. Yep.
And then they asked them questions and you got to ask questions.
Then I got, yep.
And did you ask them questions about like what do you think about police and what's
Yeah.
your feelings about
If
this?
they
And
got family in the law enforcement, would they be fair? Yeah, I still got the list, so, the questions, but yeah, basically around that.
so did they ask similar questions?
Yeah, yeah.
And some people kind of got disqualified because they were like had police in their family or they were too
Um,
biased or no?
yeah, some was too biased, some said whatever, I'm going on vacation or something with
They
work
said
and
something crazy and you're like, no, we're gonna pass on
yeah,
this
yeah.
person.
Either that or like I said, if it was, I think one guy something with work and like, he'll get fired, something like that. Like stuff like that, the judge just let them off.
So you did the jury selection in 2 days, and then how many days later did the trial start?
You know what? I could correct. Let me see. Jury probably one day, and yeah, the jury really was one day, and then the hearing was the next day, and then the trial was the next day.
Okay. So yeah, so it says that to get a conviction, the state must establish that the following specific components of the statute that you advocated, encouraged, justified, praised, incited, or solicited specific unlawful acts The advocacy targeted one of the following: the unlawful burning, injury, or destruction of any public or private property, assaults on members of United States Armed Forces, Connecticut State Armed Forces, state and local police or fire departments, the killing or injuring of any person. Intent: defendant communicated these words or writings with the willful and specific intent to promote or incite harm. And that is categorized as a Class C felony and can carry a penalty of 1 to 10 years in prison and up to 10,000 in fines. And the courts interpreting this statute rely heavily on a required finding of intent to ensure the law does not violate the First Amendment protection of free speech. So that's why, you know, your case, are you familiar with the case of Paul Boyne?
No, I was listening from your last interview.
Okay, well, long story short, he made a blog, he made a website, familycourtcircus.com. It's still up there, but now it's run by somebody else and it's not the same. When he ran it, he was putting really bad stuff, like he was putting stuff about these judges, family court ones, and saying stuff like about like anti-Semitic stuff and things like that. So these judges got him arrested for cyber stalking, electronic cyber stalking charges, said they were all scared because they felt afraid because of his blog, and they arrested the guy. They extradited him from Virginia or some other state to Connecticut and had him in jail for so long. And then they just convicted him of 20 years in prison. He got 20 years for writing a blog about judges. And so it's like, if the First Amendment says you're allowed to have freedom of speech and freedom of the press, which includes publishing things, whether you're publishing a newspaper or a magazine or a flyer or on the internet, it's your First Amendment right on the Constitution to do that. Anybody who's on American soil has that right. So nobody can tell you, oh, you're using your artistic freedom, taking a picture and matching it with lyrics and a caption and a song is a way that people can express themselves in a creative way. And unless you're actually like telling everybody, hey, everybody go attack this person, or everybody go burn down cars or do something like that, like then you could say, okay, your intent was to actually, because it says in order to not violate your First Amendment, you have to do this with the specifically intent to promote and incite harm. So the question for the jury should have been, did this post in question, was it posted specifically to incite harm, to get people to go start a riot or start an angry mob to go harm these police officers? Or was it just posted for any other reason? If there's any doubt that it was posted for another reason, if you say, well, it could have been because he likes the song, it could be because he likes Beanie Siegel, it could be because that was a scheduled post that somebody else made, it could be because it was this, that it's just too vague, that nobody's going to go look for these people just because they see that post, right? They could have been any of those things. That's doubt. They are supposed to prove beyond a reasonable doubt that there's zero doubt.
That's why I'm so like, I was so shocked to lose. Like, I mean, like I said, I'm not a law student. I'm definitely not a great lawyer, but everything I asked the questions to the officers and what they said, responded back, is no way that I could view that the jury will listen to what they were saying. Not what I was saying, what they was responding with, and say that this guy was doing what we should convict them of, like, because even they basically took it as, other than the actual officer saying he had to move and things of that nature, but because, but even in that, him having to move wasn't because of my post. Him feeling fearful is because of what he killed the man unjustly, and he's probably paranoid and having PTSD from whatever could happen to him because of what he did, not what I did. You know, I don't have a registered gun. He has a registered gun. So I should be in fear of him not being in fear of me. I have no convictions on my record of assault. You know, so it's no video on YouTube of me causing a riot and beating people up. I got a big mouth. I talk loud. I have passion in everything I do and I say, but that's it.
Yeah. Um, so just to be clear, the hook was posted as background music starting from we chapters to avoid the grave is the
Yeah,
last
yep,
part. And
yep.
the flyer had pictures of two Bridgeport cops who were involved with killing somebody from the community.
Yes.
And was the killing like unjustified?
The inspector general justified it. He definitely justified it, but the community and other communities obviously watching the video, it was unjust. He was running away. You know, he was running away. So that was my whole thing, was making noise about that. As well as other people. But like I said, I think I was just targeted because I'm always in Bridgeport, at least the biggest voice, the loudest voice, the voice that has a ripple effect throughout the government and the police department. Like, you know, when I say something, it's like, you know, they know that the community listens to me. So.
And the lyric again, what was the rapper's name from Louisiana? And also what was his lyric again?
Boozy, that one was that somebody should die. Somebody sh- somebody should somebody should die. Somebody should die with a badge on. Yeah, I believe.
Okay.
Yeah.
And so that was all the basics of that,
And
the
that's
entire, both charges, right?
the whole. Yeah. Other than they, like I said, they in the evidence they use me standing in front of the police station, with a ski mask on, putting my middle finger up at the picture of the officer. That was like a part of
Wait,
their.
hold on. You also had a picture posted of what? I'm just trying to write this
Um,
down.
is a picture of me standing in front of the police station, with my middle finger up, with a ski mask, and my hood over because it was raining that day. We was at a protest. It was a protest, so it wasn't just me there, and I wasn't the only one that have a picture, but they just used my picture.
And you said you've also actively been involved in protesting against like police misconduct over the
For the
years.
last 18 years, I've been out of prison for 18 years, from Bridgeport to New London to Hartford to Waterbury to New Haven to New York, all the way down to Washington, D.C. I've been active at hundreds of protests in the last 18 years.
And so do you believe that this is also like racism from the Bridgeport police?
Absolutely, because I have a comrade of mine who is Caucasian, and he posts and in person do similar of the actions that I'm accused of or convicted of, and nothing ever happens to him. And he knows it, and he carries on like, look, you know, I'm this white guy, so it's different. It's different me doing it over Joe Griggs doing it.
Yeah, and they also convicted you of threatening in the second degree. So, and again, like they didn't like it sounds like they didn't even explain to the jury exactly what they need to prove. Did they read the jury instructions, and did you get to
Yeah,
see those instructions?
yeah. So that was the thing too, right? They gave us that at the beginning of the trial. Then they changed it a little bit. Then they changed it every day. They changed it a little bit. Then that final day. So what I studied for my closing argument, the instructions, was basically me responding to the instructions like, this proves me not guilty. Then the day of the verdict, they gave them another one. So now what I said probably misses out, and they convicted me off of that last instruction by the judge.
And so they just kept changing it. Like I feel like that's probably not allowed either. Like they
Three times, yo, and that that pissed me off because, like I said, I'm home 3 a.m. on the floor. I got a million papers on the floor. I'm studying. I'm coming up with the right words to say. I'm a hip hop artist, so I know how to perform. I know how to get in front of people, and everybody who sat that watched the trial said my closing argument was way better than the state's closing argument. She stood there and read off a paper. I was able to demonstrate and and really say what I had to say, and that still wasn't enough. Because, like I said, everything I said went to the last instruction I was given. Then, right before they came out, they got another instruction, and that's basically I think what loopholed everything.
Yeah, and so in order to be threatening in the second degree, it says person is guilty of threatening in second degree when by physical threat, such person intentionally places or attempts to place another person in fear of imminent serious physical injury. 2, such person threatens to commit any crime of violence with the intent to terrorize another person, or such person threatens to commit such crime of violence in reckless disregard of the risk of causing such terror, or 3, does that on the grounds of religious worship. So again, you still have to make a physical threat or threaten to commit a crime of violence. And so it's like, where's the threat? Like you didn't say you were going to do something.
And not to be, feeling like Superman, but that's why when I was going along with it pro se, in my mind, I'm like, I got this. I'm gonna beat this. Like, it's not a murder charge. It's not a drug charge. Like, I mean, if it was a murder charge, I'll
It's an
probably have 5
Instagram
lawyers.
story. It's literally a picture and an Instagram story.
Right. So so
like
I
I've
felt
seen
confident.
way worse on Instagram that they don't take care about.
Right. Right. So I felt absolutely confident in doing this, and representing myself.
Yeah, but why do you feel confident having an attorney in the appeal but not in the trial court?
Well, like I said, the attorney that I was gonna take up, like, right when I asked for to obtain legal counsel, this is the same attorney. So me bonding out, I talked to him again, and he said, I'll represent you on for your sentencing.
So he's gonna go to your sentencing as your attorney?
Yes.
And then is he gonna represent you in the appeal? Are you planning to appeal immediately?
Oh, yes. Even if the verdict was a day in jail, I don't, like I said, I'm innocent of the charge. So even if
You're
it was a
appealing
day
the
in
conviction,
jail,
even if jail time's not part of it, you're still planning to appeal the conviction as soon as you receive the final order. Then you're
absolutely,
gonna go ahead with this attorney to do it.
absolutely.
Yeah, and so just from basically putting in the rest of the stuff you said, it says here that you have the facts of your case are showing serious signs of a First Amendment violation, and that you can make your appeal be grounded about the fact that they violated your First Amendment rights. The inciting injury conviction, especially, that's a violation of your First Amendment. And changing the jury instructions all the time. If the judge kept giving the jury conflicting instructions, like one day it says yes, and then the next day it says the opposite, or keeps changing the elements, or things like that, then that can be something that can be brought up on appeal. And so it also says that under some of the case law, the jury had to find, 1, that you intended to cause another person to injure or kill someone. 2, that your speech was directed toward producing imminent unlawful action. And 3, your speech was likely to produce that action. So your little story post that maybe 5 people or 10 people saw, if you have 4,000 followers, how many people could possibly see the story, right? the police sure were probably the first ones to look at it.
Yeah, yeah.
They were sure watching. So it's like, if you're posting and you have 50 million followers, maybe some of those are going to be crazy, deranged fans that are going to go do something wild. But if you have like 20 people, 50 people seeing the story, they can't say, number three, that your speech was likely to do any action, because who's going to look at that and
Right,
even think
right.
anything? People are just going to listen and be like, oh, I heard the song. Like, nobody's going to even care. And so that's, and then it also says, like, you know, your lawyer should compare your final charge and ask, did the judge require the intent to cause somebody to act? Did the judge require the unlawful action had to be imminent, like that this was going to cause immediate, likely to have people immediately do something to harm them? And did the judge tell the jury that the post had to likely cause that action, and that was your intent of posting it? And if any of those things were left out or diluted, then that's a major issue on appeal. And you know, the fact that you're a hip hop artist and there's some political aspects to this, you know, with you being vocal about police brutality and corruption and things like that, it seems like now they want to make an example out of you. And, you know, because you're an artist, like, you have more constitutional protections, because it's like putting your music, your art, you have freedom to do that. So it sounds like there's a lot of holes in this case. I haven't looked at, you know, the trial transcripts or anything, but just from what you're saying and the way that they rush to the trial, and, you know, it's like they see that you maybe aren't sure what to do, and instead of like advising you and saying, okay, sir, you have 30 days to review the discovery, and then we're going to have trial is going to be in 6 months. Trials shouldn't be in, but they couldn't do that because guess what? They had 12 months to do that and they didn't. So that's another thing you can throw in there, that they, instead of dismissing the case, they tried to rush with the trial, and they should have given you all that discovery like a year ago. So,
Right.
yeah, I think that, you know, you know, do you have any idea though? Like, does this lawyer have any kind of idea, maybe, or suspicion of what he thinks your sentence will be?
Not yet. Coincidentally, I'm actually going to talk to him a little bit later today because I just kind of got like a little extra. Something came up last night that should help with this case. But I'm gonna talk to him today and view what he thinks. You know, now. But you know, he's a good. He's from the New Haven area. Alex Twabs, I think how you say his name. So you know,
Oh,
he's
Alex
dealt with.
Hobbs.
Yeah, he's dealt with a lot of these type of situations before, so I'm confident in him. You know that he definitely gonna do. He's gonna do way better than I would that I could do. So.
And so does he also believe that your rights were violated, your civil
Oh yeah,
rights?
yeah. Yep.
And so are you going to go to court on Monday prepared to get taken in, like, just in
Yeah.
case? And
Yeah,
then,
absolutely. Every day this last month, I've been I'm actually right now just outside of my daughter's home and about to walk with her and just I've been just with the kids. I actually recorded a whole album in this month. Trials and Tribulations 2. It'll be out on Monday. It speaks on most of the things that we talked about during this segment. And then it just, you know, it's just another way for me to have a voice if I'm incarcerated.
and so if you do get incarcerated, will somebody also be putting updates on your social media so everybody
Yep.
knows like
Yeah.
what's going
Yep.
on?
Yeah.
And
Yep.
you
I'm gonna
can
make sure
also
that.
update them of the conditions in the prison, because I know
Yeah.
it's horrible.
And I'm pretty sure that they're gonna be spiteful towards me in there too. So I'm trying to prepare for that as well. Like I know how it is with guards and you know things I've said about the prison system as well. That I feel like they're gonna definitely try to you know mess with my mental and my physical. And you know I'm just preparing for all of that. But I definitely whether it's my brother, my kid's mom, or a friend, somebody's gonna definitely, try to update and keep my social media platforms like you guys knowing what's going on. Because I'll
And
definitely
who knows,
call.
maybe they'll just give you a suspended sentence, or maybe they'll give you something else. We don't know. So,
With,
but it's
with,
good
with
to prepare.
I would hope so. I definitely will hope so because the PSI went great with the PSI investigation went great with that officer, and then I have like 20 character reference letters from the highest, from reputable politicians to business owners to family members, and nothing is made up, nothing is a lie. For the last 18 years, I've been a community activist, a father. I have ill people in my family that I have to take care of now. My daughter is special needs. So, for me to just be incarcerated, it doesn't only incarcerate me. It definitely is detrimental to other people,
Yeah.
So
And hopefully the judge takes into consideration, like, nobody was harmed by
right,
anything that you did. There was no real victim. The cops can't sit there and really say that he's scared. And the only people who would suffer, like you said, are your children, who would be without their father, and people missing you, and it's not justified for what they're alleging that you did, which again violates your First Amendment. So
right.
would you like it if people tried to come there on your sentencing to show
Oh yeah,
support?
yeah, yeah. Two
And so again, it's
p.m.
at Bridgeport. Where is it? Tell again. What is it?
Bridgeport, Connecticut, Golden Hill courthouse. That's downtown Bridgeport at 2 p.m. Yeah, I would love
On
the more
Monday.
support. The more support of obviously looks good in court. I do have people that's going to show up. But I don't mind when I went to trial. People, because like I'm a hip hop artist, I have fans that I never even met that just follow me on social media. People showed up to the trial, and I met them that day, and they
But do
just
they
was like,
live stream it or no?
no, because they did. That's the thing too. They're so fearful of
Secretive.
my social media. They take
Yeah.
they won't let anybody in the courtroom with phones because like I don't know that.
Bridgeport is, I'm telling you, that one time they said if I let somebody use my phone, they were going to take my phone and not give it back. I was like,
Oh
you
yeah.
can't do that.
Oh,
They're crazy.
don't pass me a phone in the courthouse because they're gonna take your phone. They say I can't touch no phones in the courthouse. Somebody else took a picture of the officer while I was during trial. I didn't know that they took the picture and they posted on social media and they banned everybody with their phones and they stopped. They took my phone.
Oh
So
my God. All right. Well, thank you so much for your time and explaining everything. And, hopefully you'll have good news on Monday and have like the best possible outcome. And hopefully
appreciate that.
then we can get the appeal. Your appeal can get going right away immediately, and everybody can stay updated on that. And I think having public pressure and exposure, even people watching the appeal, that like puts pressure on the state, because then they can't do so much corruption if they know, okay, we have a lawyer who knows about constitutional stuff. Now he's filing this appeal. Now it's public. Now thousands and thousands of people are paying attention. We got to follow the rules. So
Right.
hoping for the best for you. And thank you again so much. And so we'll talk
I,
soon.
I appreciate you. I will say this: I've been doing podcasts and interviews all month, and this one right here has been the best one that I was able to explain the case. And then obviously you having your law education, and so you understand what I'm saying. I'm understanding what you're saying, and me being a hip hop artist, all my interviews, they talk about the hip hop, they talk about the music. So I never really got into the case. So this has been like the best one that I can repost and people could understand what was going on. Because a lot of people, you broke down each charge. They just see threatening. They don't understand. They're like, oh yeah, he did threaten the person. But you broke down the intent and different things like that. So I'm happy that you had me as a guest today. And with my quote unquote big following that they think, I'm definitely gonna share. I'm gonna share this platform and get people tuned in. Like everything you're doing is great, being that you're going through what you're going through, but you're also educating yourself on the law to become, somebody that could represent those that don't know how to represent themselves.
Absolutely. Well, thank you so much, and I'll be praying for you.
Thank you.
Okay, thank you so much. We'll talk soon. Okay, bye.
Salute.